Really taken aback because there was nothing in that document that required the attention of, but the bundles, it will be properly placed. 8 February 2018, I was following up with Fanny, sorry to call him Fanny, with Mr. Dingiswayo and Ms. Ngoye on our discussion on investigation reports. So certainly, the allegation that I was only interested in CIA matters is really, it's not correct. Between me and them, there were issues that I directly engaged them on, besides the ones that I've talked. With regard to this memo, is dated 8 February 2018, and in terms of protocol, you don't just write to the person you are. I go through their their senior, who was the group CEO, and raise up with them. And I referred to my meeting, my engagement with the two officials, and I wanted to know what they did when I asked them about this Makhubele report. They delivered so many files to me to read. And I managed to read a bit that there was a review application that was pending in court. One, Lucky Montana, was reviewing that report of the derailed report, and the minister was cited as a respondent. And I realized that PRASA had filed some affidavit which they said was to clarify certain inconsistencies. But then, actually, to me, they said they had filed an affidavit or submissions to clarify certain inconsistencies. But when I went through the bundle of documents that they gave me, I discovered that PRASA, as a matter of fact, filed an opposing affidavit dated 19 July, and it was deposed by Onika Martha Ngoye. And I just quoted one paragraph there, where she says PRASA is accepted to implement the remedial action of the public protector because they are binding. But she contradicted herself, because on the same breath, she answered the merits of the legal and factual arguments that Lucky Montana had put forward as grounds for opposition. And I asked the question whether PRASA can, in view of the fact that it has joined in the opposition of this review application, start with implementation of the remedial action. And I wanted us to have further engagement about this particular report, and which I was saying Makhubele Huntley, because they were on record, they needed to seek council's opinion to advise the board on whether PRASA can, under the circumstances where it's actively participating in the merits of the review application, start with implementation of the recommendation before the matter is finalized in court. With regard to National Treasury, when I met with them and when they gave me a report that the investigation is complete, and that's how we reported to the Parliamentary Committee on Transport when we appeared there on 24 November 2017. However, it subsequently emerged that the investigation was incomplete, and at some point, these National Treasury reports, preliminary reports, were leaked, and in the media now and again you'll find parts of them. And the board then, and they were masqueraded as final reports. This is by this newspaper, Ground Up, to which, as far as I know or remember, is the one that was publishing these reports from National Treasury. And the board directed management to obtain written confirmation from the responsible officials at National Treasury with regard to the status of their investigation. And I think I received a verbal report, and then also, which was then followed by a written confirmation by National Treasury that the investigation is still ongoing. And as you can see, another misleading information given to me. I've already spoken about Verman's when I dealt with the issue with Ms. Ngoye. Let me just see what I have omitted. Yes, because we requested Verman's to give us an executive summary on each and every one of what they said was 60-odd reports, and they refused. I remember they attended a meeting with us, brought so many boxes of reports and told the board to read for itself. The meeting didn't end well. It didn't end well. It was almost physical, because they were, it didn't end well. They left, and they called us, the board, that we were hindering their work, and we were in fact obfuscating the issues. There was a follow-up by the group CEO to Verman's management to demand an apology on the manner in which they treated us, and some of their executives came, Messias Manaka, and July, they apologized. That was it. That was the end of our attempt to get anything out of Verman's. But as I've already indicated, we persisted with wanting to answer the questions that Parliament has asked us, and then that's when Mr. Kenna approached the board because he wanted to clear his name that no, it is not the one who appointed Verman. I've already talked about authorized payments like she did in this matter, but then the chairperson said he himself is going to sign invoices. So these are matters that I had engaged them. So I don't want to repeat myself. It's not true that as far as they know I was only interested in the CIA matter. I did not have direct dealings with Mr. Dingiswayo after the reports were from Mohasha. The employees and their office were provided to me. When we asked why they were not attending meetings, there would always be excuses from the CEO that they had excused themselves for one or other reason. And to me, those were valid excuses. And to me, because at the time, yes, it was courteous to engage them, but Ms. Ngoye was not the one dealing with litigation. She was not a litigation. Mr. Dingiswayo was the general manager, and the attorney or lawyer dealing with the files was one Ms. Mukotedi. And as you have heard the evidence of Mr. Dingiswayo, he said this CIA matter or claims were small matters. So one wonders if it's small matters, they never had any interest in these matters. Their interest was only elicited when, according to them, the CFO wanted to pay. And from the evidence of Ms. Ngoye, she was not asking them to sign anything, just to give advice. So I'm saying, if CIA claims were big matters, anyway, in which event Dingiswayo says there were small matters, which explains why they did not know what was happening in the matter, which explains why, yes, Mohasha was briefed, he was conversing with the attorney allocated, but when it comes to issues, certain issues, I felt at some point they, as the seniors to this particular junior attorney, should have been involved. I've seen Dingiswayo's evidence where he says, with regard to the insolvency inquiry, he only received the transcripts or saw the transcripts in February of 2018. Well, he has already been taken to task by my legal team about his evidence about the inquiry. I will not repeat that evidence because it's not his. So I'll just touch on specifics of his evidence that I need to respond to. I know nothing about what happened in court between him and Advocate Bottas. I only later learned that about those letters, but I was no longer dealing with him. Actually, I never saw him until we met at the Office of Minister Zimande, as I've already testified. I just want to comment on his evidence in as far as there may still be questions after his cross-examination. Can I please just check volume 8? If you have a hard copy of volume 8. This is an email from, I just want to comment to this email because it talks about what I'm alleged to have said. I don't know, to him, Fanny, Dingiswayo, or it doesn't say to who. This email is in page 292, volume 8. It's an email from Fanny Dingiswayo to dated 18 January to Rose Manyosa, email address at Prasa and others at Prasa. And I have no knowledge of the context of this email. He was referred to it, but I just want to comment that I know nothing about what he says here about me. He says, when the board was appointed, the chairperson of the board indicated to us that she had some knowledge of the matter and indicated that she would, from that point on, handle the matter herself and communicate to the lawyers herself. The chairperson has not shared the information that was in a position with us. We were therefore excluded from the matter and believe that we are barred from dealing with the matter, as we had a view that was different from the chairperson on prospect of success. In the circumstances, the only time that we can be able to be involved in this matter is when the chairperson of the board has indicated that we can be involved in the matter. We therefore cannot be of any of assistance at this point. This email highlights a very important thing, that he is telling whoever he is writing to that he will only be involved when I tell him to. But he believes he has been barred. I don't know. Now I think this is where the allegation about having been barred comes from. He doesn't say who told him he has been barred. He just say he believes. But in the evidence before you, tribunal, he says he was told that he was barred. And the sequence of events indicated in this email is incorrect, as I've already testified, that I never said I have knowledge and I'll deal with the matter myself. I just wanted to see what's in this email because I noted it in my notes. I just want to look at what I can do. He says he was asked whether before that memo directed to the Mr. Z that I had consulted with him, and he seems to deny, but he says Ms. Ngoye told him that I consulted with her. My recollection is that I met with the two of them after Botes left, and that's when we spoke about the matter. If you recall, in my memo, I mentioned whether Mukhasho had instructions in the insolvency hearing and what those instructions would have been. Ms. Dingiswayo said they briefed him, but he didn't participate. And if you read the transcript, not the commissioner's report, the transcript, on many occasions, the legal team of PRASA was given an opportunity to say something, and they did not. They just left their, I understand it was not adversarial, same as what we are doing here, but you consult with your witnesses that are going to testify and know what they'll testify about to assist the commissioner. And the witnesses did exactly that. They were given instructions to come back with more information, which was one of the concerns, the costs, because if you brief an attorney and counsel to just go and sit and give moral support to your own witnesses, because that's what it says here, is the employees said they would feel better if lawyers were there. The other, next thing that I need to comment on, it's about the report of Baltec. Well, Ms. Ngoye said she never saw it. But Mr. Dingiswayo says he submitted a report, meaning his report. Kobius did and Baltec did. But when asked whether he knows the, let me just get my facts clear. He denied having told Baltec not to cooperate with the commissioner, but this was confirmed by Mukhashwa. I may not have put it in that way, but Mukhashwa said he knows there were instructions to cooperate, but that let me leave it there. He, when confronted with what Mr. Baltec said, he attempted to discredit this Baltec person. That he was in trouble because he had signed some contract without authority. But this information was never brought to me or the board, or even when, at the time when questions were asked about those who testified, they had an opportunity to say, this person testified in this manner because of this. This was never brought to our attention until in this hearing. And more so, he knows that Baltec has testified, has submitted a report, but he doesn't say anything about the alleged troubles that he had. Any further? In his evidence, he says Mukhashwa came to his office and he asked why he was not going to a meeting. He told him not invited. And he doesn't want to know what it's all about. And the next time he called Mukhashwa to inquire about status of Siaya, and Mukhashwa says he was barred from speaking to him. But in the email that I've just read, he doesn't say this. He says he believes he was barred. I mean, if he was bold to write other things about me in this email, he would have mentioned it. He testified, but he was just a bystander who, in his mind, knew that these claims were not good, and all the other bad things he testifies about. But he doesn't advise the board, he doesn't advise me, he doesn't tell any person. He says he met a friend. This friend told him about the fact that Mackenzie was expecting money, and then he then thought, yes, this could be money from these claims. And he says from time to time, he thought about CIA matters and wonder what was happening. This is an official of, this is the litigation manager. He is worried about some serious unlawful activities that are unfolding. He just sit by his window, watch Mukhashwa walk in and out, and put an ear on the ground for information as to what is happening. He does not advise the board. I do not think this is, he had a duty, and deliberately, if we were making a mistake and he deliberately withheld information, I think that's the worst kind of dereliction of duties. About court, I know nothing about what happened. I've already explained that I was only alerted to Botha's activities when I saw the exchange of letters between Mr. Dingiswayo and Matopo attorneys. The rest of his evidence under cross-examination, I think these are matters for argument, but what I need to comment on is that he says Ms. Ngoye was his role model. She knows the law, and so when they advised each other not to use the SACA panel is because they know the law. But we heard what happened, that they were mistaken. And they were not even prepared to listen to reason, because sometimes you think you know the law, but last week there was an amendment that you are not aware of. So you need to have an open mind. But these two officials held the view that using a SACA panel would be unlawful, and repeated requests to engage them, they refused for, and 5 years later, then they are humbled. That Section 217 of the Constitution and many other legal things. But I believe those are matters for argument if you would be interested in them. Motivate someone to make allegations about the next person.